Hello and welcome to the first in a series of webinars being run by Metis Partners. My name is Nat Baldwin. I head up the corporate recovery team here at Metis Partners, and I am joined by my colleague Eileen Jaffa.
Good afternoon, everyone.
And we're just going to take you through the first in the series today, which is the basics of intellectual property assets in insolvency and distressed situations. So just to start with, who are we? We're market leaders specializing in valuing and selling IP assets in financial distress and corporate insolvency scenarios. We work mostly here in the UK, but with some North American, European and Asian experience, and we sell the IP assets mostly from UK insolvencies globally. Our corporate recovery team provides commercial, practical advice on how to deal with IP and insolvency or distress scenarios, but I think it's important to say we're not lawyers. Whilst we can advise on how to put a value on IP assets, how to extract a monetary value, a monetary return out of these, it's important obviously to get the correct legal advice when you're dealing with intellectual property assets. Especially on points such as licensing and then contractual protections and ownership and those types of aspects. So what have we been up to over the last couple of years? These are some of the IP assets that we've sold. Lots of brands, lots of patented technology. We have valued a very wide-ranging number of asset classes in lots of different businesses. Just to give you some recent examples, we've been valuing an IP in a company that does experimental technology focusing on the conversion of natural gas to syngas, a company that did electrochemical technology, an asbestos consultancy, a confectionery company, Toffee and Fudge, that was a tasty one, a software app, which was a competitor to a service like Deliveroo. So a real mixture. IP assets come obviously in many different forms. So enough about us. What are we going to cover in this webinar? We are going to look at why is it worth looking at for IP and insolvency. Then we're going to talk about IP asset classes that have value in insolvency, the basics of those, what are some of the value indicators, so what to look for, what are sort of triggers for looking for value, tips to preserve and maximize that value, and then we'll also look at 5 key takeaways from the session. If you have any questions, then please I think there's comments box or questions box, so please do ask questions and we'll try and cover those at the end. So without much further ado, I'm going to hand over to Eileen, who's going to run through the core of the subject matter today.
Thank you, Nat. So why should we all keep IP in insolvency in mind? First of all, we all know that IP comes in different shapes and forms. The registered IP asset classes such as trademarks, patent portfolios, even websites and domain names tend to be the easy ones to spot, but it always pays off to look for the non-obvious ones, the ones that aren't registered, not in the spotlight in most businesses, but the ones that often attract quite a bit of value. Over the last decade or so, we have all witnessed a clear change in the business landscape, and we can all see that new types of businesses are making their way into the market, sometimes by offering products and services that didn't exist a few years ago. So software development companies, energy developers, technologies for renewable energy, energy storage technologies, the life sciences sector as well. They tend to all move to a completely new, different form of R&D and innovation level. And we now see that companies where intangibles hold most, if not all, of the value in quite a few cases. So from a insolvency point of view, the main takeaway is probably to keep in mind that when looking at a new case, consider the commercial value of the assets rather than just the underlying problems and issues around those assets. Sometimes the prospect of getting a good commercial return justifies spending some time to smooth out the underlying issues, such as unclear ownership or practicalities of transfer, and taking a commercial approach can help get around those and move a case to get a good return. Moving on to our first IP asset class for today, brands and trademarks. Now, a trademark is a symbol which can distinguish the goods and services of one trader from another. It takes the shape of words, logos, pictures, sometimes a combination of all these as well. And trademarks offer their owners the opportunity to oppose similar limitations, imitations or copies on the market. One point that's worth noting is that trademarks tend to carry only as much value as the brand that they protect. So trademarks behind well-known brands can be sold for significantly more than ones that relate to brands with minimal exposure. So in any case, a good trademark portfolio can add significant value to the brand. Whilst unregistered trademarks tend to carry certain risks, for example, proof of use is required to establish ownership, and there might be competing market players that could try and do that as well. There are ways to mitigate these risks even in insolvency. For example, in cases where we've seen strong brands without trademark protection, and we have completed a couple of those in the last couple of years. For example, McEwen's, Paul Simon, both big brands in the retail sector. And we have, in these cases, advised the insolvency practitioners to file trademark applications following their appointment in order to prevent third parties from spuriously registering trademarks once it becomes evident that the business is in insolvency. With registered trademarks, one thing to keep an eye out for would be the registration details, especially if these are the trademarks are held in the name of different employees or directors, just to avoid complications further down the line. That's worth keeping in mind. Another tip for dealing with registered trademarks, especially to spot high-value trademarks, would be to look at the classes, the goods or service classes that these trademarks relate to, and the territories, because it always tends to widen the pool of potential purchasers for these types of assets. Moving on to patents, one of the most obvious IP asset classes. The patent usually protects new inventions and covers how things work, what they do, how they do it, what they're made of, and how they're made. Three main elements usually have to be met in order to pursue a successful patent application. The invention must be new, there must be an inventive step, and it must be capable of industrial application. When we think about the value of the patents, valuing patents is not the easiest of jobs, it's not the quickest of jobs. One simple thing that can be done in the first instance, usually when you come across a case with patents, would be to do a quick citation analysis to get an initial idea of the commercial value of the patents. And a citation analysis, put simply, involves looking at the patents to try and understand if these have been cited by other patent owners or other businesses for the purposes of different applications. As I said, valuing patents can often be quite challenging, and it requires quite a bit of in-depth analysis and time. So usually our viewpoint is, if there's a patent portfolio that sits well alongside the business operations of a company, try and sell that on day one. If you can't, there would be more liabilities around renewals and practical issues to consider. So selling patent portfolios independently from other assets usually takes a bit longer to market. There are certain commercial, legal, and technical hoops to jump through when discussing them with potential purchasers. So keep that in mind, and also try to establish contact with the patent agents as early on as possible, because they are usually the best people to provide you with a good visibility of the size of the patent portfolio, any upcoming renewals, licensing deals that already exist, costs for renewals, all things that should be kept in mind if you're selling or trying to run a marketing exercise for a patent portfolio.
That's right, Eileen, and I think that it's an important point to understand that there can be significant renewal costs and prosecution costs that will occur during an insolvency. So just bearing this in mind, it's something that the patent agent should be able to assist with understanding which patents are valuable, which patents can be perhaps let go that don't relate to current products and services. I think in terms of the commerciality and the value, you've touched upon it, but there can be value that sits out with the rest of the assets. So patents can be maybe described as acontextual, so they're not contextual to the business, they are standalone rights to some extent. And certainly we've done plenty of cases where we've been selling patents to non-practicing entities and patent aggregators, so particularly US granted patents would potentially be the most valuable, although we should say that the market has become depressed for patents over the last 6 to 12 months. Previous to that, we were seeing some pretty high prices being paid for US granted patents.
So moving on to the third registered IP asset class that we will be looking at today, designs. They tend to be slightly lower in value compared to patents and trademarks. Designs essentially relate to the appearance or part of a product, and the key requirements for a design to be capable of being registered are the design being new and making sure that the design creates a different overall impression in comparison to earlier designs. As I mentioned, value is generally not as high as patents and trademarks. However, registered designs demonstrate good management practices and create a perception of high value and usually make the IP asset package more attractive to purchasers. Having said that about registered designs, our experience in the last few months, especially working on cases in the oil and gas sector, suggests that there's some businesses can have a considerable body of unregistered designs, which could be quite attractive to third parties, especially things like processes or components. So we have dealt with purchasers who have been prepared to pay solid six-figure sums for these. So definitely don't overlook information that's held electronically on servers, hard drives, and computers at companies' premises. There's likely to be some body of design work that's worth looking into and marketing. Moving on to copyright. It's in contrast to the previous classes that we discussed, copyright is an automatic right, so it doesn't require registration as such. It gives the creator of an original work exclusive rights to its use and distribution, and usually gives them an opportunity to generate revenues through licensing as well. When we think about copyright, from our experience here at Metis, I think the most valuable copyright protected assets tend to be software, and we'll pick up on software a bit later on today as well, and databases. Actually, an example of a piece of software that we've sold a year ago, a bit more than a year ago now, is WeWorld, which was a top 10 social media website in the US amongst the young generation. So that copyright applied both to the software of this actually, and both and also to the design of the little weenies, which were the little characters that were key to the platform. When we think about copyright, especially in insolvency situations, a useful tip would be to consider, especially when you look at blog content, magazine content, any written content or marketing content that is held by the company, to consider who has created that content, whether it's the company itself or any external writers, journalists, marketing agencies, as that usually defines the scope of ownership and should give insolvency practitioners visibility as to how much right they have to sell on. The next IP asset class, trade secrets. It's the type of closely held information which can take the form of unpatented inventions, formula, designs, recipes. For example, one that also comes quite prominently in press once in a while. Some of you may remember a few months ago, there was some speculation around the leakage of the recipe for KFC's mix of herbs and spices. The company eventually denied those speculations. However, it just goes on to show how critical trade secrets could be to a business, and what a significant impact it may have on the reputation even on the business following on. Trade secret value is difficult to define usually, and it doesn't tend to be an IP asset that could be sold independently from the other IP assets, but it's a good value add asset, so to speak. And the knowledge that trade secrets are included in the IP asset package usually encourages purchasers to offer significant sums for the overall IP. Websites and domain names. We tend to analyze these in terms of website content and the domain names that host this content. When you think about the value of those assets, it's usually dependent on traffic and the website functionalities. We've seen in several cases where an e-commerce website or a website with very rich content is capable of attracting more value than something relatively basic. Domain names, on the other hand, can hold significant value even if the website content itself is not of superior quality. For example, the wider the applicability of the domain names in terms of sectors, the higher the value it could attract.
That's right, Eileen, and also it's worth thinking about whether there could be a domain name that would be a hidden gem in a job. So particularly companies that have been around for a while might have one-word domain names that potentially have higher value, two-letter, three-letter, four-letter domain names. If you think about it, there are only, well, I've done the maths, there's only 676 two-letter domain combinations. So if you've got one of those, then that's going to be valuable. I did look this up, this is on Wikipedia, but Hewlett-Packard was the first company to register a two-letter domain name with HP, and American Airlines were the first company to buy a two-letter domain name, AA. Now, if you come across one of these, they're obviously going to be significantly more valuable than long 3-4 word domain names. So there is a whole world out there of traders in domain names, and we've got access to that market. So just worth bearing in mind that there could be a hidden gem in some of these jobs, and worth just looking at the domain name list. The other thing to note on domain names is possession is 9/10 of the law. So you might know or understand that the domain names are owned by the company, but if you don't have control over the account that holds the domain names, you can forget about trying to get any value back. We've been several negotiations. There weren't really negotiations with some of the domain registrants like Nominet, who will just tell you that that you need to fill in forms, and you just get nowhere with it. So you really need to get someone on board early who has access to the domain account, so that you can package these up and sell these on.
And software, we touched upon it very briefly earlier in this presentation, and I promised that we'll come back to it. So when you think about software, I think there's no denying that most companies use it in some shape or form. It's either off-the-shelf third-party software that's been brought into for a specific function, such as accounting or stock management, or there might be a bespoke piece of software that the company has created itself or has outsourced the creation of in order to carry out its core business capabilities. Now, in terms of value, revenue-generating software, as usual, I think with most assets actually, revenue-generating assets, it tends to have more demonstrable value than pre-revenue software, so it definitely tends to be more attractive to purchasers when they're considering whether it's an attractive piece of IP. That's not to say that pre-revenue software isn't valuable. Actually, our experience selling these types of software suggests that if it's a piece of well-written, high-quality software that functions well, it doesn't have many bugs, there's a significant return to be made out of this. Also, there are technical elements to consider when dealing with software and its attractiveness to the wider market, such as the programming language or the frameworks it's been created in, as purchasers also tend to really look for something that aligns well with their current operations, so quite critical in terms of salability. Common pitfalls when dealing with software. One of them is control, making sure that if you are the appointed insolvency practitioner, have control of this, or understanding who has control of this upon engagement, as it's often the case that companies have external storage or backup services that they use, and they're on a subscription-based manner, or and if payments cease at that stage, the contents in the account can disappear very quickly. We've had a recent example of that. We were selling a piece of aggregator software, and the cloud service provider had been sending the director a number of emails to remind them that the outstanding fees should be paid. However, these had slipped through the net, and the service provider then went on to wipe the chunk of the most recent call on the account, leaving only historic backups available. So there was a bit of a problematic case around this. So one point to keep in mind, if you were to try and preserve value and maximize value, ask where the code is, who has control of it, who's got the relevant passwords, have the invoices been paid for the hosting. And the last IP asset class that we'll briefly look at, data, it's becoming more and more valuable. Selling it is equally becoming riskier due to the number of regulatory developments coming on in the recent months and in future months as well. So it's one of those types of assets which could attract a significant value, but there are a number of hoops to jump through, and for that reason, actually, we've developed a product called Validator that assists insolvency practitioners go through those various stages and secure a maximum return for the data assets. But stay tuned, and you will probably hear from us in the next few weeks as well, because data will be the topic of an upcoming webinar.
Thanks, Eileen. Just recapping and to give you some thoughts to take away, these 5 key takeaway points. I think one of the main things to do is think about commercial value. So focus on how intellectual property assets link to revenues. Beyond that, look for the hidden gems. So we've talked about domain names, we talked about pieces of code that might have applicability to other businesses, pieces of organizational knowledge. All of this we've seen has sold for a good return to insolvency professionals, and creditors have often been pleased to get an additional return out of assets that, quite frankly, they didn't know existed within the businesses. Keep the assets live. So when you go into a business on day one, think about, is it commercially viable, and is it worth keeping assets live? For example, websites, software, I mentioned hosting, all of these things, you should at least be thinking about those on day one to think, is it worth it? Is it worth paying that renewal fee to keep the patent alive? It's coming up in 2 weeks' time. That type of thing will all help to preserve value, because there's nothing worse than coming in on a job and something's been let go 2 days previously and erodes value. Pinpoint, and part of that, I suppose, is the 4th point, pinpoint who holds the key to the IP assets early on. So we tend to rely on personnel within the company because it's just too much of a leap to try and understand technically what's going on within these companies. The people who have the expertise, often IT directors, for example, when you're dealing with software, they need to be kept on side. So if you need to be nice to them, be nice to them, because they are the types of people who will hold a lot of value when you're trying to sell the asset further down the line. And the 5th point is this takeaway is an IP asset checklist which we've actually created specifically for insolvency professionals. So it's something that perhaps you can be taking out to your jobs and asking questions of the directors and other stakeholders and teasing out whether there's any IP value that perhaps haven't been considered before. So we will send you this link out, a link to this IP asset checklist to the participants of the webinar, so please feel free to use that. So that's actually brought us to the end of the webinar. It's been a whistle-stop tour. We set ourselves the task of getting through this in half an hour, and I think we've just about managed to do that. Just looking, please, if you've got any questions, type them in quickly now. One question that's come up is, are there any sectors which you tend to deal with or where IP doesn't exist? That's a good one. So certain sectors tend not to have IP value that's readily realizable. It's not a hard and fast rule. Construction industry tends not to be one where tends not to be a lot of value in there. The basic rule of thumb is think about the type of industry that the company's operating in, and do they see value in IP? Because if competitors see value in IP, they're probably going to be prepared to pay for it. So the obvious examples, the ones that we've gone through, retail, software, even manufacturing, they will. You wouldn't traditionally think of them as understanding IP, but specifications and things like this, organizational knowledge, as Eileen mentioned, know-how, these all have a lot of value. So worth considering. I'd say worth considering IP on every job. Whether you actually do something with it is another thing, but it's worth thinking about whether there is value. So that brings us to the end of the webinar. Thanks very much for participating. We will be running a number of other webinars in the series, and we'll be back in touch with you to firm up the dates for those. So hopefully this has been a good spend of time, and we'll be back in touch shortly. Thanks for listening.
Thank you very much.